Good morning, friends. Let us dive into another case law which is in the syllabus of Advocate on Court Examination and has been recently added in the syllabus. Friends, I am talking about case law SUBHASH DESAI versus Principal Secretary, Governor of Maharashtra. It was decided on 11th May 2030, 2023. The bench comprises Honorable Chief Justice of India, Dr. D.Y. Chandrachud, Justice Mukesh Kumar Arsha, Justice Krishna Murari, Justice Hima Kohli, Justice P.S. Narasimha. The questions involved in this case are whether a notice for removal of a speaker or deputy speaker prevents them from deciding disqualifications for defection proceedings under the 10th schedule of the Constitution. Second question was, can the High Courts or the Supreme Court decide a disqualification petition for defection under the 10th schedule if the speaker has not yet taken a decision? What is the status of proceedings in the Legislature during the pendency of disqualification petitions against members? What is the role of Speaker in determining the whip and leader of the Legislature party? How much discretion does the governor have to invite a person to form the government, and can courts review the governor's decision? So, friends, these were the 5 questions which were put before the Honorable Constitution Bench for decision. Now, coming to factual background. In June 2022, Mr. Uday Thackeray, who was part of petitioners, was the Chief Minister of Maharashtra and the party president of Shiv Sena Legislative Party, shortly SSLP. Mr. Eknath Shinde was part of the respondents, was the group leader of SSLP. Subsequently, the SSLP split into 2 factions, one led by Mr. Thackeray and another by Mr. Shinde, and each side claimed to be the real SSLP. Mr. Shinde's faction violated a whip issued by Mr. Thackeray's chief whip, calling for a meeting of all Shiv Sena members of the Legislative Assembly. The faction led by Mr. Thackeray then issued a resolution removing Mr. Shinde as group leader of the SSLP and filed disqualification proceedings against Mr. Shinde and his MLAs on the ground of defection under the 10th schedule of the Constitution. At this stage, the office of the Speaker in the Maharashtra Legislative Assembly was vacant. The Deputy Speaker took up the disqualification proceeding and issued notice to Mr. Shinde and his faction. Mr. Shinde's faction, in turn, issued a notice for removing the Deputy Speaker on the grounds that the Deputy Speaker no longer enjoyed the support of majority in the state legislature. In November, Arabia, a constitutional bench of 5 judges of the Supreme Court had held that such a notice prevented the Speaker from deciding disqualification proceeding. In the meantime, the Governor of Maharashtra issued notice to Mr. Thackeray requesting him to prove his majority on the floor of the House. Before the floor test would be held, Mr. Thackeray resigned as Chief Minister. Subsequently, Mr. Shinde, with the support of MLAs from the BJP, was appointed the new Chief Minister and new Speaker was elected. The petitioners filed a writ petition before the Supreme Court seeking to quash the appointment of Mr. Shinde as the Chief Minister, while the respondents filed another writ petition praying that Deputy Speaker be prohibited from taking any action under the 10th schedule against Mr. Shinde's faction until the issue of the removal of the Deputy Speaker was decided. These writ petitions were combined and heard before the Supreme Court. Mr. Shinde filed a petition before the Election Commission of India, shortly Election Commission, under the Election Symbol Reservation and Allotment Order 1968 for allotment of the symbol of the Shiv Sena, that is bow and arrow, to the faction led by the ECI ruled in favor of Mr. Shinde and granted the symbol to Mr. Shinde's faction. Now coming to decision of the Supreme Court. The Honorable Supreme Court held that the Speaker must recognize the whip and leader of the Legislature party as appointed by the concerned political party. In the event of split, the Speaker can decide if MLAs of any faction ought to be disqualified, and Election Commission can decide who can use party symbol. Both these decisions can be taken concurrently, and neither the Speaker nor the Election Commission needs to wait for the other decision. The Supreme Court held that, except in extraordinary cases, neither the High Court nor the Supreme Court can decide disqualification proceedings under the 10th schedule of the Constitution. The court further held that an MLA had the right to participate in legislative proceedings while disqualification petitions are pending against them, and the validity of the decisions taken by the legislature cannot be questioned merely because disqualification proceedings were pending against certain members. The Supreme Court ruled that a governor is only justified in calling a person to prove their majority on the floor of the legislature if the governor has reasons to believe, based on objective material, that such a person has lost the confidence of the majority of the legislature. On the issue of whether the Speaker can decide disqualification proceedings when a notice for the Speaker's removal is pending, the correctness of the decision in Nawab Arabia was referred to a larger bench of 7 judges. Until the issue is decided by 7 judges, the court held that Speaker had the authority to examine whether a motion for their removal was genuine or merely intended to stop them adjudicating to a disqualification proceeding. If the Speaker found the removal motion to be genuine, then they could pass the disqualification proceedings till the decision of the Speaker removal was concluded. Else the Speaker could reject the motion. The judgment of the court was unanimous and authored by Honorable Chief Justice Chandrachud. Now let us dive into the reasons for the decision. A reference of Nawab Arabia to a larger bench. Supreme Court noted that the correctness of Nawab Arabia was in doubt because it conflicted with the judgment of Kihoto Holhan. In Nawab Arabia's constitutional bench, in Nawab Arabia, a constitutional bench had held that the speaker ought not to decide disqualification proceeding once proceedings for the speaker on removal has been initiated. In Quixote Holhan, another constitutional bench had held that the independence and impartiality of the speaker when adjudicating disqualification proceedings cannot be doubted. Given that both decisions took divergent views on the independence of speaker, the court referred the correctness of Nawam Rabia to a larger bench. The court found that the facts in Nawam Rabia were different from the present case and that the decision in Nawam Rabia would not apply to the present case. Now, coming to power of higher courts to decide disqualification petitions in the first instance. The petitioners argued that the speaker cannot be entrusted to adjudicate the disqualification petitions fairly since he was appointed with the support of Mr. Shinde's MLA against whom defection proceedings had initially been filed. The Supreme Court rejected the argument and held that under paragraph 6 of the 10th schedule, the speaker had the exclusive jurisdiction to decide the disqualification petition. Barring any exceptional factual circumstances, the court should not decide disqualification petition. However, the court could review the final decision of the speaker. Now, friends, coming to validity of proceedings in the legislature during pendency of disqualification petition. The petitioners contended that the validity of decisions taken by the legislature while the disqualification petitions were being decided would depend on the final outcome of the disqualification petition. The Supreme Court rejected this contention and clarified that if the members incur disqualification, then their seat shall become vacant only prospectively from the date of their disqualification, and an MLA has the right to participate in the proceedings of the legislature until they are disqualified. Otherwise, all the decisions of the legislature would become uncertain and unworkable as soon as disqualification petitions were initiated. That proceedings in the legislature during the pendency of disqualification petitions were valid. Now, appointment of whip and leader of the legislature party. The Supreme Court highlighted that there was a difference between the political party and legislature party under the 10th schedule, that the two terms are not the same, one and same. In the context of 10th schedule, the legislature party consists of only of those members of a political party who had been set up for election by the political party and have been elected to a seat in the legislature. The court found that speaker must recognize the whip and leader of the legislature party that was appointed by the political party. Since the members of the legislative party are elected due to their affiliation to the political party and owe their allegiance to that political party, the court therefore held that the resolution removing Mr. Shinde as the group leader of the SSLP issued by the Shiv Sena faction led by Mr. Thackeray was valid as it represented the will of the political party under the Shiv Sena party's constitution. Deciding who is the real Shiv Sena party and allotment of the party symbol. The petitioners argued that when defection proceeding and a dispute over which faction can do the party symbol before the election commission have arisen simultaneously, then the disqualification proceeding ought to be decided before the election commission decide on the party symbol. Since the later dispute would determine who was the real political party for determining defection. The court, however, stated that the election commission can concurrently decide which faction can use the party symbol even while disqualification proceedings are going on. And both decisions need not to be the same as they are based on different considerations. The speaker decides disqualification petition as and when they are initiated, while the decision of the election commission would only have prospective effect and will not affect the decision of the speaker. Impact of deletion of paragraph 3 of 10th schedule. Paragraph 3 of the 10th schedule stated that a member of the legislature would not be subject to disqualification if there was a split in the original political party where one-third or more members separated to form a different political party from the original political party. However, paragraph 3 was deleted by the Constitution's 91st Amendment Act of 2003. The Honorable Supreme Court categorically stated that the defense of split was now no longer available to the members who face disqualification proceedings, regardless of whether such members claimed to belong to the original political party or not. In this case, both factions claim to be the original SUBHASH political party. Exercise of discretion by governor ordering chief minister to face floor test and inviting a person to prove his majority in the legislature. The Supreme Court said that the governor can only order a floor test requiring the chief minister to prove their majority based on some objective material, which indicated that the chief minister had lost the confidence of the legislature. In this case, the court found that there was no such objective material present and that the governor of Maharashtra called for a protest based on the request of some MLAs only. While this was not in accordance with the law, the court recognized that Mr. Thackeray had voluntarily resigned before facing the protest and the court could not reverse a voluntary resignation. So this was all about friends case law. Enjoy, read again and again so that you may get good preparation on this topic.